Welcome back to Justice Redesign. I'm Stephen Teskey, your host, retired judge. Now, I'm interrupting our series, one that we're about to partake in called The Measure, to drop this breaking news that also updates our previous bar card series and episodes, ending with Todd Blanche and his involvement in the Anti-Weaponization Fund and the tax immunity for Trump and his family. So let me break it slowly by saying this. There is a saying in the legal profession that every trial lawyer eventually learns. You can persuade the jury. You can negotiate with opposing counsel. You can even convince your client that a difficult compromise is the wiser one. But there's one thing no lawyer can do. You cannot ask a court to pretend. A courtroom is not a stage. A judge is not a prop, and litigation is not theater. A lawsuit exists for one reason: to resolve a genuine dispute between parties with opposing legal interest. That simple principle lies at the heart of Article 3 of the United States Constitution. And this week, ladies and gentlemen, a federal judge reminded the nation why. If you've been following this series, the Bar Card series, The Breakdown of Justice, you know this moment didn't arrive out of nowhere. Months ago, I published an essay on my Substack account, Justice Redesign, asking what many considered an unusual question: can a president effectively sue himself? At the time, that question sounded almost absurd. But it wasn't intended as rhetoric. It was intended as a constitutional analysis. When President Trump filed suit against the Internal Revenue Service, the IRS, and his own Department of Justice later negotiated a settlement after return to office, I argued that the issue was larger than the settlement itself. The question was whether the federal courts were being asked to legitimize an arrangement that lacked the essential ingredient every lawsuit requires, which is a genuine controversy between adverse parties. Folks, that is in the United States Constitution itself. I'm not making this stuff up. This is not statutory passed by Congress or state legislatures. This in the Constitution is put there by the framers of the Constitution. And today, a federal judge has independently examined that same question, and her answer was unmistakable. One of the mistakes we often make in today's political environment is reading headlines instead of judicial opinions. So let's set politics aside for just a few moments. Can we do that? Let's look at what the court actually found. Judge Kathleen Williams concluded that this lawsuit was not simply unusual. She concluded that it represented an attempt to use the judicial process to provide legitimacy for an agreement conferring extraordinary benefits that had not arisen through an ordinary adversarial legal process. That observation, folks, is very important. Notice what she did not say. She did not merely criticize the settlement. She questioned whether the court itself was being asked to serve a function the Constitution never intended. That's a profound institutional concern. The framers understood something about human nature. Government officials, even well-intentioned ones, sometimes desire the same outcome. Now, if courts simply approved agreements because everyone wanted the same result, judges would cease to be independent arbiters. Come on, that goes without saying. They would become just simply participants. That's why Article 3 limits federal courts to deciding actual case and controversies, where there are two people who actually have a real conflict, who really want to go at each other, and it needs a court to resolve the dispute. Okay? Now, we're not talking about policy debates or political agreements, not coordinated arrangements. That's not a case or controversy. We're talking about real disputes, real disagreements, real adversity. That requirement protects something much larger than the parties. It protects the legitimacy of the judiciary itself. As I read Judge Williams' opinion, one passage stood out. She concluded that the plaintiff and the government had become what she described as a fully realized unitary interest. I want you to think about those words, okay? Not adversaries, not opposing litigants, just one unified interest. They're all working together for the same objective. Come on, why would you need a court if you're working together for the same unified interest? That observation goes directly to the constitutional concern many scholars had raised from the very beginning. If both sides seek substantially the same objectives, the court is no longer resolving a controversy. It is being asked to bless an agreement. I mean, something they already agreed was going to happen before they went into it, probably before maybe they even filed the lawsuit. And that is not the role assigned to the judiciary. The opinion reaches beyond this particular dispute, folks. It reminds us why the judiciary was intentionally designed as the least democratic branch of government. Remember that conversation I had with you in the Bar Card series? Federal judges are insulated from elections for a reason. Think about that. Not because the framers distrusted democracy. It is because they understood that constitutional rights sometimes require judges to reject what powerful majorities or powerful officials desire. That is when majorities decide to, and powerful officials decide to run amok, okay, and hurt the minority. The judiciary cannot perform that function if it becomes dependent upon political approval, nor can it perform that function if it allows itself to become a participant in executive arrangements rather than an independent constitutional referee. Remember the separation of powers. The opinion also addressed the conduct of counsel. Now, this is where it gets interesting. And this is where the real update is as it relates to the Bar Card series. Judge Williams referred one attorney to the Florida bar for possible disciplinary proceedings. And she stated that she would forward the opinion, her 56 or something page opinion, to the New York disciplinary authorities in connection with their ongoing investigation. Remember the ongoing investigation involving acting Attorney General Todd Blanche. Remember, I spoke about that. Remember my Bar Card series? I predicted that Todd Blanche was eventually going to get investigated. There's going to be a bar complaint. I wasn't anticipating it to be this early, but it's happening. Okay. Just like Pam Bondi's moment she got terminated by Trump, all of a sudden you have 100 plus, judges and lawyers who filed a bar complaint against her. That referral, folks, is not by this judge, federal judge, that referral to the New York bar is not a finding of professional misconduct. I want to make that clear, nor is it a disciplinary sanction. It is the beginning, though, of a professional process which no lawyer wants to go through, designed to determine whether ethical obligations were violated. See, folks, that distinction matters. Due process matters. Fairness matters. They matter for everyone, especially lawyers. And one of the themes we've explored throughout the series is that institutions often protect themselves in ways that are not immediately visible. Congress performs one function, the executive another, the judiciary another, state bar authorities yet another. Each serves as a different safeguard. When one institution encounters constitutional concerns, another may examine professional conduct. That's not duplication, folks. That's constitutional design. Different institutions, different responsibilities, the same commitment to preserving public confidence in the rule of law. I have no interest in predicting the outcome of any disciplinary proceeding. I could care less. Maybe, but that is for the appropriate authorities to decide. nor do I view this opinion as a victory for one political perspective over another. I view it as something much more enduring. Reminded that courts exist to decide genuine disputes, not to manufacture legitimacy, not to ratify agreements, not to lend judicial authority where constitutional adversity is absent. The framers entrusted judges with an extraordinary responsibility. Sometimes their most important word is simply no. Thank you for joining me. I'm Stephen Teske, your host, retired judge. Until next time, remember that justice is not preserved merely by laws written on parchment. It is preserved by institutions and by people willing to honor them. Until the next episode, y'all take care. Be safe.